And of course, we have a really tough act to follow. So, welcome everyone. If you're in this room, you're not in the romantic room. We were told that the human rights presentation was the romantic presentation. This is, I guess, the more practical one. But welcome. My name is Paul Carlscott. I'm a partner with the law firm in the U.S., Baker and Hostetler, and I run our nationwide class action defense team. I have a defense-oriented practice. I'm very pleased to be moderating this exceptional panel of three really impressive gentlemen. And we're going to be talking about the use of statistics in class certification and class action proceedings, both in the United States and in Israel. In the US, statistics and econometrics have been used for many years to support damages models in certain types of litigation, including some that we've heard already, securities fraud, including cases involving fraudulent statements that are taken into account by the market, antitrust competition claims, employment disparate impact claims, where you have a claim that a particular practice has the effect of discrimination. And a key common feature of many of these cases is that there's an alleged common injury suffered by an entire class of individuals or businesses, even though the degree of damages might vary. So you have a common injury, but the damages may be variable. And in the US especially, the courts seem to be okay with allowing an aggregate damages model in those cases. But over the past decade, we've started to see similar damages models being used in other areas, including in cases where there are variations not only in the amount of damages, but in the very existence of injury. And we're starting to see that in a variety of places, including cases involving food labeling, where you have an allegation that there's a misrepresentation in a product, but clearly not everybody who buys the product has read the misrepresentation on the label. I see it in my own practice in data breach litigation, where there's been a data breach, and 99% of the class doesn't complain of anything other than receiving a notice in the mail. We see it in pharmaceutical defect and other mass tort claims. And in these cases, the plaintiffs typically argue that statistics are appropriate because they provide an efficient path to evaluate needed remedies where there's been some common misconduct. Now, I'm on the defense side. We respond that allowing statistics to be used as a shortcut in these cases, where there's in a lot of cases, a significant portion of the class has not suffered any injury at all, deprives the defendant of due process, it prevents them from challenging injury and damages as to the large majority of the class that hasn't been injured at all. We're going to be exploring these issues today through our three presentations, and I'm going to leave the three panelists with a series of questions that hopefully they can address during the course of their presentations. First is, are statistics a legitimate way of generating common answers to questions where the alleged conduct is common, but the impact of that conduct is not common, or not uniform, or not even existing? The second question, are statistical damages models, as used in some cases, essentially a trial by formula, where you take the decision maker out of the equation at all? The next question is, are statistical damages models, as used in certain types of class actions, junk science? Or are they misapplied forms of real science? The next question, does eliminating the ability to challenge individual injury and damages claims violate notions of fairness and due process to the defendant? And then finally, should courts be less scrutinizing over statistical damages models in cases where the defendant's alleged misconduct is uniform, even though the impact of that conduct is not? So I'll leave those questions for the panelists to address as they see fit. Our first panelist is Brian Keating, who will introduce us to various statistical and econometric methods that are used in class action litigation in the United States and elsewhere. Brian is an executive vice president with Compass Lexicon based in Washington, D.C. He specializes in the economics of industrial organization and antitrust economics. He has been involved in numerous class action disputes and is co-author of a chapter on econometrics and regression analysis in the American Bar Association section of antitrust law called Proving Antitrust Damages. Welcome, Brian.
So thank you, Paul, and thank you to the organizers. For better or worse, you have to listen to an economist for at least 10 minutes. Try to give a little bit of a sort of a crash course in how we think about using regression analysis, statistical analysis in the context of both estimating damages broadly, but also in the particular context of class actions. So just to give a little bit of context, Paul gave a bit of my background, but it may be useful to think about what I'm going to talk about today. So, as I said, I've worked on a bunch of class action proceedings. They've all been in the context of US class action, so that's the perspective from which I'll talk today. I think you've heard a lot in the past day or so about US class action law versus standards in other parts of the world. I think a lot of what I'll say today is generalizable. Some of it may be specific to the US context. But I think, at least from the perspective of economics, the economics is pretty universal. And the methodologies I'm going to talk about are pretty universal. So I'm hopeful this talk will be helpful not just to US practitioners, but to practitioners in other parts of the world. As Paul said, my background's in antitrust. Most of my work is in the context of competition policy or antitrust suits, things like price fixing, broadly speaking, market division cases. And so, again, some of the examples I give will be in the context of antitrust, but the methodologies I'm going to talk about are they extend beyond the antitrust context. So we heard this morning about Rule 23. I won't spend a lot of time on it, other than to say that the place where I think the economics is most relevant is on Rule 23A2, which is, are there questions of law or fact, in particular fact from the economic perspective, that are common to the class? This is one of the questions that Paul posed today. Is there a role for statistics and economic analysis in addressing the question of commonality? I think the answer is yes. It has to be done carefully, it has to be done appropriately, but done in that way, I think economics can be quite a powerful tool. And I will try to provide some more details on that. So what is regression analysis? Broadly speaking, it's a statistical method. One wants to analyze the relationship between what economists call a dependent variable. So in the context of an antitrust case, for example, you might want to be looking at prices, you might look at output, and you want to figure out what factors affect the dependent variable. So for example, you might be interested in how do different product characteristics affect the price of the product? How do the cost of manufacturing the product affect the price of the product? And the reason you care about these things, and in particular in the context of estimating damages model, is the question you're really interested in is what's the effect of the alleged conduct? And in many cases, you're not going to have a single price. You're going to have many different products possibly sold in different markets under different supply and demand conditions. And you might have a wide variety of prices. You might observe those prices over time, going up or down. And some of that variation in price may be caused by the conduct of interest. Other pieces of that variation may have nothing to do with the conduct. Right? You may have a shock to supply. Right? You may have, in the context of airlines, for example, you might have a shock in fuel prices that has nothing to do with the alleged conduct. You want to control for these things. You want to isolate the piece of the variation in price or whatever variable you're interested in that's due to the conduct, while figuring out what effect the other pieces have. So regression analysis is a tool that can be used to sort out the heterogeneity in the data. One thing that's really important, I think this goes to one of the questions Paul asked, can statistics be misapplied? Of course it can. We see it all the time. One thing that's really important is that when you talk about econometrics, regression analysis, it's not just a statistical model. Right? It's not just taking a bunch of data and throwing it in a computer program and running regression. You really need to tie the model back to economic theory, to economic principles, and to the facts of the case. And one of the places where this comes up is how do you design the right regression model? How do you decide which variables are important? We talked before about the dependent variable, the explanatory variables. How do you decide which variables you want to put in the regression? A lot of that's driven by economic theory. A lot of that's driven by understanding at a pretty deep level the facts of the industry that you're analyzing, right? So you want to know what costs are relevant to assessing the question of interest. What demand factors are relevant? How do I go out and figure out what data I need to collect to run a regression analysis that's meaningful? And a lot of that comes not just from a numerical analysis, it comes from economic theory. So just very quickly, I have a very simple example of what a regression analysis looks like up on the slide. So on the vertical axis here, we have price. You can think about that as the dependent variable. This is a very simple model. We're just going to think about what effect cost has on the price of a product. Each dot on this graph represents an observation, right? It might represent a different product or a product in a different market. And what you can see is the dots are scattered, right? There's a clear upward trend in the relationship between price and cost, but it's not linear. What regression analysis does, it tries to figure out the average effect of the explanatory variables here, cost, on price. And so what you see is this solid line is a line of best fit. It's what the regression is telling you. It's saying on average, the effect of the cost on price is the slope of this line. So in this example, we have a change in cost results in a change in price. The coefficient, the relationship between the change in cost and the change in price is 0.9 in this example. So it's saying for each 1 unit change in cost, you're going to have a 0.9 change in price. So there are a bunch of different ways to figure out sort of what the relationship is. I'm going to talk about a few common methods that are commonly used. So one approach is a benchmark approach. So the idea here is to figure out a place where you want to look at observations where there's sort of no effect from the conduct at issue, and you want to compare it to places where you do see an effect. So one example is a cross-sectional analysis. So you might have a variety of markets, some of which are affected by the alleged conduct, some of which are not. And you might think about running a regression where you look at prices in the market that's not affected, and markets where it is affected. You might also have time series analysis. So you might look at periods where there's no effect from the conduct. Thank you. Excuse me. So you might have a conduct at issue. You might see that conduct start at a particular time. You might want to look at how do prices behave or how does output behave before the event happens. And you want to see, look, I observe prices time t, event happens at time t plus 1. How do prices change? So you might have variation over time. You might have variation across markets. And you can use that in the regression analysis to try to figure out what the effect of the conduct is. More broadly, you might have both cross-sectional analysis and time series analysis. We can use that in what we call a difference in differences analysis. And the idea there is you might look at trends in prices in a set of markets that are unaffected by the conduct, trends in prices in a set of markets that are affected by the conduct. You can see how those trends deviate from one another, if they do. And that might give you another way to identify the effect of the conduct at issue. So what role does regression analysis play in class actions? Really, the core purpose of the regression analysis, what it's doing is it's trying to answer a question that's fundamentally unobservable. What's the counterfactual? What happens if what happens in the absence of the challenge conduct? We don't observe that world, right? There's some alleged event, there's some alleged conduct that happens, and it has an effect on prices. We want to know, when you're estimating damages, what would prices have been, what would output have been in the absence of that conduct. That's not something we observe. That's something we need to use statistics to figure out. So one role that regression analysis plays in class actions is to identify an empirical basis to determine whether there's a causal link between the challenge conduct and the effects of the conduct, right? So if we see a price fixing conspiracy, we want to look at, Paul talked about what the impact is. We want to look at, did that conspiracy have an effect on prices, right? The regression analysis can help you figure that out. It can also quantify the magnitude of the effect, right? So when we talk about damages in the context of class action, we need to figure out not just was there an effect, right? You might think that, for example, in a price fixing case, it's a per se violation, there's going to be some effect. How do you figure out how big that effect is? Again, regression analysis can provide a tool that allows you to quantify that effect. The other piece, and this goes back to Rule 23, that regression analysis can play is it can allow you to assess commonality, right? So regression analysis, it can be used to assess an average effect, right? You might say, okay, I observe prices go up by 20% on average at the same time that we have documentary evidence of an alleged conspiracy. Okay, we have an average effect of 20%. But as Paul said, that might not affect all class members, right? You might have some class members whose prices went up by 40%. You might have some class members whose prices went up by 0% or 2%. Regression analysis can help you sort of figure out not just the average effect, but it can allow you to assess the effect either for individuals or for subgroups of the class. And it can really play an important role when it does that. So, last slide. Averages are sometimes not sufficient to ascertain class-wide impact, right? When you think about the question of is there, are there facts that are common to the class? Just saying, okay, I observe prices go up by 20%, it's not always enough. Now, if everybody's buying the same product, if everybody's buying a product that has the same price, the average might be enough. But that's not always the case, and frequently it's not. We might see a group of conspirators or alleged conspirators who are setting prices across a broad array of products. The conspiracy might affect some products but not other products. Customers may be buying a mix of products. And so regression analysis can play a role in helping you sort of sort out the individual effects, right? So you can, with sufficient data, which is the big caveat, we don't always have good data, but if you have enough data, you can use things like fixed effects. You can analyze the effect of the conduct not just overall, but on individual class members. So we'll pause there and hand it back over.
We want to make sure we stay on schedule. Thank you, Brian. There are probably 50 other concepts that Brian could have talked about there, but I think regression is a really good place to start because that's one of the ones that comes up a lot. So thanks for that primer. Our second panelist is Derek Ho, and Derek's going to talk about some developments in the use of statistics in class actions in U.S. law. Derek is a partner at Kellogg Hansen, a boutique litigation firm, also in Washington, D.C. He represents plaintiffs and defendants in class actions and other complex commercial cases across the United States. Derek and his firm are responsible for several of the leading U.S. Supreme Court class action precedents in recent years, including the most recent decision in Tyson Foods. Derek?
Thank you, Paul, for the kind introduction. Rabia asked us to try to wrap this up by 10:45, which is in 10 minutes. But so I will try to keep this very short. Paul asked me to speak a little bit about a case in which we were involved in 2006 at the U.S. Supreme Court called Tyson Foods against Buafacchio. Bouafakio is a name that gives any litigant shudders because it's impossible to pronounce, but that is the official pronunciation. Tyson Foods was a 2016 Supreme Court case that, much to the surprise of observers, upheld certification of a class in a Fair Labor Standards Act case. It was an overtime case involving workers at a pork processing plant in Storm Lake, Iowa. And to understand Tyson Foods, it's important to understand a little bit about what Supreme Court case law was looking like in the lead up to Tyson Foods. There had been a number of decisions coming from the Supreme Court in the 5 years or so prior to Tyson Foods that had led the plaintiff's bar to worry and the defense bar to hope that there was going to be a very severe restriction on the ability of plaintiffs to use statistics in order to obtain class certification. As an even further backdrop to that, there had been several cases about class arbitration waivers, as Sam mentioned. We haven't talked a lot about that at this conference. We were involved on the defense side in actually being sort of the architect of some of these cases. But in many ways, the class action is disappearing because in any situation in which there is a pre-existing contractual relationship between the plaintiff and the defendant, in almost every case by now, there is a waiver of the right to proceed on the basis of a class action. I would say it's almost malpractice for a defendant with a contract not to have an ironclad class action waiver. And those waivers, in significant part due to the case law that we helped develop on the defense side, were upheld in two controversial cases in the lead up to Tyson Foods, a case called Concepcion and a case called American Express against Italian Colors, where we represented American Express. So there was concern among the plaintiffs' bar about that. Then there was a case called Walmart against Dukes. Walmart against Dukes was, I think to this day, the largest class ever certified. It was about 1.3 million Walmart employees. And it was a discrimination case. And the problem with Walmart was that there was no common policy of discrimination shown. Instead, the evidence was that there was no common policy. Instead, there was discretion among individual hirers, managers, about hiring decisions. And the way that the plaintiffs tried to overcome that was to use statistics. They wanted to take a representative sample of employees, figure out how many people within that representative sample had been discriminated against, and then extrapolate that to the entire population. That's, of course, a perfectly valid statistical method. We use extrapolation from a representative sample all the time. But the argument was, and it prevailed in Walmart, that this was improper as a way of trying to prove liability because it was, as Paul referenced, trial by formula. It deprived the defendants of the ability to contest as to each individual whether or not the employee had actually been discriminated against. And the court in Walmart disapproved of that concept of trial by formula. And there was a second case called Comcast against Barron 2 years later, in which the court rejected class certification of an antitrust case on the premise that there needed to be a common method of showing damages. This was an assumption of the Comcast case, not a holding, but an assumption that seemed to be received favorably by the court and then applied in that case as a way of rejecting class certification. So when we get to 2016 in Tyson Foods against Bouafakio, I think many observers thought that Tyson Foods was going to be used as a way to extend Walmart's disapproval of the trial by formula concept and apply it to an even smaller class of people. Again, this was a group of employees, about 3,000 employees, not 1.3 million, in a single plant in Storm Lake, Iowa, where, as in Walmart, there were some differences. It was a case about whether or not these employees should have been paid for putting on the special protective equipment that they have to use in order to kill pigs and then carve them up in order to create the pieces of meat that then wind up in your grocery store. It's not a pleasant sight or a pleasant thought. And there were differences in the particular kinds of equipment that the employees had to wear. If you were killing the hogs, you had to wear protective equipment because you were using very sharp knives, much longer knives than if you were simply processing them, etc. So there were the same kinds of differences in the class that Walmart had, and the issue was whether or not these folks had worked more than 40 hours a week and therefore were entitled to overtime pay. And so the amount of time that these folks took to don and doff, put on and take off their equipment differed from person to person. As in Walmart, the plaintiffs tried to use statistics to overcome those differences, but unlike in Walmart, they used, I would say, much cruder methods. The plaintiff's expert in Tyson Foods, all that he did was take 744 observations of people, different employees, donning and doffing their equipment, separated them into two groups, the folks that killed the hogs and the folks that processed them, and then took a straight average of the amount of time it took to don and doff the equipment, and then said that for all the plaintiffs, they could be deemed to have worked the average amount of time. Nothing like the kind of more complicated, I would say reliable statistical extrapolation that the plaintiffs had offered in Walmart. I think the second fear was that the court in Tyson Foods would actually turn Comcast's assumption into a holding and say that indeed you did have to have a common method for proving damages. But as it turned out, the Supreme Court did neither of those two things. It actually reached the exact opposite conclusion that I think a lot of observers were expecting. By a vote of 6-2, Justice Scalia had died in the intervening period. The court approved the class certification, upheld the class certification. With respect to trial by formula, the court, I think, fairly severely limited the ability of the defense bar to use this notion of trial by formula as a way of undercutting the use of statistics to demonstrate the existence of a class. Trial by formula really was the mantra of the defense bar in the period between Walmart and Tyson Foods. In virtually every case that I did in the district court, there would be an accusation that the plaintiffs were trying to use trial by formula. So what Tyson Foods did is, I think, severely limit Walmart's trial by formula. It basically described Walmart as a case that was extreme in the size of the class and narrowed, I think, the scope of the Walmart holding. And second, it rejected the notion that you need to have a common method of proving damages in order for there to be a class, and restored what I think was the pre-Comcast conventional understanding, which was that the need to have individual trials on damages does not, in fact, impede class certification for lack of predominance. I'm running out of time, so let me just say that I think that the upshot of Tyson Foods is to make the use of statistics more viable for purposes of demonstrating liability and shift in some ways the terrain of the debate from whether or not statistics can be used to whether the statistical methods being used are reliable. And I say that because one big feature of Tyson Foods was that there was no challenge to the reliability of the methods that were being used under Federal Rule of Evidence 702. That issue had been waived by Tyson Foods, and the court made a big point of that. And I think that in cases going forward, there's going to be a lot of discussion about whether or not the methods are being used are being reliable, and that's why we'll be hiring Brian's firm to do more and more work in the future.
Thanks, Derek. Our last, but certainly not least panelist is Itamar Anabi, who will be addressing a key development in this area of statistics in our host country of Israel. Itamar is the head of litigation department of S. Friedman and Company. He has been representing for many years clients in commercial disputes in courts and arbitrations, as well as defendants in class actions, and also serves as an arbitrator himself from time to time. Itamar? Try to get your. Where is it?
Slide.
No. Oh, it was here before. Oh.
High face, really?
No, it went away. I think we'll have to go without it.
Do we?
Yeah, I'm sorry.
Good morning. I prepared a slide, but apparently it's not here. So first of all, I have it here.
I'll take it around. I'll be your Vanna White.
No, I'll show it later, please. Paul, okay. All right. First of all, I apologize for ruining the perfect American accent that you heard so far here. In fact, when I was invited to participate in this panel, I had another topic in mind, but Ariel asked me to address a specific case, which is one of the milestones in the history, relatively short history of class actions in Israel. So this is what I'm going to refer to talk about this morning. It is a case, it is really one of the milestones in Israel, and it was filed against the largest food producer in the country called Tnuva. For the sake of full disclosure, our firm represented the defendant in this case, and I personally was involved in the last stages, including in particular the appeal to the Supreme Court of Israel, which was decided in 2010. To me, this case is the embodiment of the expression, hard cases make bad law. And as you can understand, we did not win this case. The story, in a nutshell, Tnuva is a monopoly in the field of milk production in Israel. It produces fresh milk, as well as the UHT milk, which is the milk that can be stored and consumed several months after its production. Tnuva owns several dairies in Israel, and in one of them, in 1994, the dairy which produced the 1% fat UHT milk discovered a problem. The problem was that foam was accruing over the top of the milk, of the packaged milk. Sorry about that. Just lower. You still hear me? Okay. What they decided to do, the management of the dairy, decided to add to the milk a food additive named E900. This was the official name of the additive. It is nicknamed in the industry silicone. And this food additive can be found in numerous food products like jams, soda beverages, etc. It can also be found in an over-the-counter medication sold for babies. Now, the people of the dairy added the E900 to the milk, and much to their satisfaction, it worked. It solved the problem, but did not solve the other problems which were, first of all, it is not allowed to add anything to the milk under the milk standard in Israel. Secondly, you are supposed to mark whatever the packages contain on the package, which they did not. Apparently, the dairy people were aware of the problem and decided not to share this information with the management of Tnuva, of the company. This lasted for about a year and a half until in 1995, in a weekend magazine, one of the two leading newspapers in Israel at that time, the headline was, "Industrial Silicon in the Milk." It caused a huge scandal. First, since Tnuva is the largest food producer in the country. Second, since milk is associated with the beginning of life, babies, etc. And third, because since the journalist did not call it the food additive E900, but in order to increase the impact, he called it industrial silicon. The journalist knew, as we all do, that if a food additive is associated with food, while industrial silicon is associated with plastic surgeries, with strong sealing material, etc. You would not want to drink it in your milk. On top of this, the story was published on a Friday, and the next day the management of Tnuva denied that the E900 was added to the milk. Shamefully, they had to retract the denial several days later, but this was too late publicly and had a major effect on the legal outcome. Just to give you an example, and this was the picture, the slide I wanted to show you. This is the newspaper. Here in the middle, Rabin, which was the prime minister that was assassinated a month and a half later, talks about the murder of Jews by Palestinians will not stop the peace process, which is a very important issue in Israel at that time. But on top of this, a much more important issue. Tnuva admits we added the silicon to the milk. So, a few days later, an application to certify a class action was filed. And one of the most complicated issues the court had to deal with was the damage. The question was, what, if at all, was the damage suffered by the people who consumed the milk? The Supreme Court first dealt with this question at the certification stage, which was decided by a majority vote, and it decided to certify the class action. The court decided to define the damage as an infringement of the individual's autonomy. Putting it simply, the consumer is entitled to know when he makes his decision what food he would like to eat. He is entitled to make this decision based upon a full and correct information. After it was certified, the case went back to the district court of Tel Aviv, who began dealing with the merits. The evidence, and here I come to statistics, the evidence submitted included a survey, two surveys actually, that were conducted by the parties shortly after the story was published in the media. However, the surveys turned out to be completely irrelevant to the decision of the district court. Why? Because the legal approach taken by the court was that once the right of the individual was infringed, due to the non-disclosure of full information, the damage has occurred automatically. As the court stated, the damage is inherent to the wrongdoing. Therefore, the question of causation between the wrongdoing and the damage became irrelevant. And the compensation was awarded to all the members of the group, to all the consumers. In the appeal, the Supreme Court had to address various allegations raised by Tnuva. The one relevant to our discussion was based on the survey. This survey showed that only part of the class members have experienced hard feelings when they became aware of the real facts. They described feelings that range from disgust to anger. However, about 30% of the class members were quite indifferent. Part of them even assumed that the UHT milk, as opposed to fresh milk, contained ingredients that were added to the milk in order to preserve its quality for a longer period. Why, asked Tnuva, should these people be entitled to compensation? On this level, we won. The Supreme Court, based on the survey, made a distinction between those who suffered hard feelings and those who were indifferent, and awarded compensation only to the first group. The survey provided the Supreme Court a way out from the unreasonable results of the purely academic approach taken by the district court. And in fact, this case established the importance of statistics in the class actions in Israel. The number of questions that this case raises is countless, and is, in academics and lawyers keep discussing it, but the time is short, of course, and I would like just to present only one question in the context of surveys. And I'm going back to the question of reliability that Derek mentioned. The question is, how reliable is a survey that deals with consumers' hard feeling in such circumstances? Obviously, if the survey was conducted before the story was published in the media and inflated by it, the results would have been different. The findings of the post-publication survey reflected not only the hard feelings of the consumers that became aware of the fact that the food additive was added to the milk, but also the hard feelings that were inflated by the media and the buzz it created, the association with industrial silicone, and the denial at first by the management of Tnuva. There is an inherent prejudice when a survey is conducted in such circumstances. Is there a way to neutralize the impact of external noises when a survey is conducted following a public scandal? I will leave this question to the survey's experts. Thank you.
Thank you, Itamar. I am fascinated by that case, but in the interest of time, we'll take questions after the next break and leave it to the next panel. Thank you all.